7 minutes past the top of the hour. Karibu sana. This is Morning Cafe. I'm just really Stanley Nyuringita. Welcome to Law Matters, because that is what we do every single Thursday. Have our Wakili here to help you understand the legal issues around you. And today we're discussing matters, lands and property and assets, particularly for a deceased person. Now, did you know that interfering with the land of a deceased person can attract jail time? Well, now you know, and Wakili will be telling us all about that and much more that we actually don't know on matters meddling with the property of a deceased person. Karibu sana Wakili.
Thank you, asante.
You can give us a brief intro of who you are, or you practice. Pretty sure later on, Kimalizia show, you'll also be sharing a contact for in case someone hatakuwa ameshika or they have more to ask.
Okay, thank you. My name is Paul Macharia Mushiri, an advocate of High Court of Kenya and a practitioner of law here in Kenya, and also the managing partner in the firm of Macharia, Gaidho and Moriko Advocates. Yes. Right.
Speaking of contacts, our phone numbers are open. 0795 045 864 is the number to talk to us and throw in all those questions or feedback that you have concerning this particular conversation when it comes to interfering with the estate of a deceased person. 0795 045 864 is our number. On WhatsApp, 0793 267 279. We'll be having those numbers just below your screens in case you don't get them right now. So you can talk to us on WhatsApp. 22047 is our SMS number. Particularly today, I think Wakili will be skimming through the Law of Succession Act.
Yes. And
just understanding what these particular sections really mean. But then, when you take a look at this bit, as much as it has a sound very subtle, at you usiinterfere na shamba ama property ya mtu mwenye ameaga. Many people have found themselves either directly or indirectly involved in such. And they're being told we're going to jail you, and they're wondering why. So first of all, even you help us understand what this means. Help us understand also what is the thinking behind that you're going to jail someone for this.
Okay, thank you. And the court has been so careful to deal with the estate of a deceased person. The reason is, unlike the property of a living person, the person once deceased, there is no one, there are so many other forces that may intervene to prejudice the beneficiary, the rightful beneficiary of the estate of a deceased person. Two, this deceased person may have made their wishes on how they would like their properties divided. So at all cost, the court will try to ensure that that is fulfilled. The third reason, this person is not there to defend themselves. So the only guarantee they have is if the law is followed with regards to whatever they owed while they were alive. Because anyone else, there is potential of someone taking advantage of the estate, that which is not defended per se. Yes, that's why the law is a bit very strict in terms of how it should happen. And actually, when you look at the interpretation of the will, because that's the document essentially that ought to be before the court, or to be used when the deceased had made their wishes, the court will, in the most circumstances, try to ensure that the wishes of the deceased are fulfilled and applied to the latter, because the deceased cannot be resuscitated for him to explain what they wanted.
So how does the law interpret interfering and intermeddling? It sounds like a very complex word. Ni kama umeenda kusumbuana na kama mtu alikuwa na property, unaenda kuchokoza huko. What does it define as interfering?
It's not a complex word. And actually, the drafters of the Law of Succession Act, Cap 160 Laws of Kenya, did not define per se what intermeddling is. For these two reasons. One, when you define something, you confine it to the definition you've given.
Does it then, but then, does it open a gap?
Yes. Two, there are so many things that can be done that may not be defined. You see, when you are coming up with a definition, it means you have settled on something, what there is. And through the applications of the court have tried to list some of the possibilities that may be construed to mean intermeddling. Because when you read section 45, it says no intermeddling. Of course, it is a statement from the negative.
And now the fact that you even mentioned it, even for the viewer to understand what you're talking about. So the section 45 of the Law of Succession Act, we can take a look at this infographics that help us understand different. We'll take a look at section 45 as well as 46. But Director, if we can have that when you're ready. 45 talking about no person shall, for any purpose, take possession or dispose of or otherwise intermeddle with any free property of a deceased person. Clause 2, any person who contravenes the provisions of this section shall, first of all, be guilty of an offence and liable to a fine not exceeding 10,000 cash shillings or to a term of imprisonment not exceeding 1 year or both to such fine and imprisonment. And the second one there, be answerable to the rightful executor or administrator to the extent of the assets with which he has intermeddled after deducting any payments made in the due course of administration. You've told us about, well, the first one. Before we even cross over to the next slides, let's first deal with this section 45 and help us understand what it means. We still have it there. So first of all, saying be guilty of an offense, you've rightfully told us why. The court has that. Be answerable to the rightful executor or administrator. What does this mean?
Thank you. And I wish to first take the title.
Please.
It says no intermeddling with the property of a deceased person. The immediate section, that is subsection A, it tells or it gives a warning. The act from the first to the end doesn't define what intermeddling is, but then it attempts to tell that which may amount to intermeddling. One, and that definition and that application has also been explained more by the court. These are some of the circumstances that may mean and include, but not limited to intermeddling. One, if you possess the estate of a deceased person. 2, if you sell. 3, if you lease. 4, if you charge. 5, if you convert. 6, if you attempt to deal with it in any other manner. For example, you attempt to harvest the proceeds of the estate. There are no unlimited reasons or circumstances where one may interfere. And the reasoning is, when somebody dies, people come up with various interests. One, there are those who may want to occupy. There are those who may want to dispose it of. There are those who may want to charge it. There are those who may want to mortgage it. There are those who may want to convert it so that it becomes their property. So all those circumstances, there are those who may interfere with those who are there. There are those who may inhibit the progress or the gains made by the estate as a result of that property.
Right.
Now, what the law envisions, and the clause 2 says that you shall be answerable to the rightful administrators. What it means, the framers of the law, what they intended upon death, and actually you will understand, and we will explain to the viewers, upon death, there are so many avenues by which you can approach court to benefit from the estate of a deceased person.
So this makes you as an administrator, or?
Yes. Now, there is a hierarchy of those who can approach the court as administrators.
Right.
So any person, not administrators, dealing with the estate of a deceased, then they are intermeddling. The law gives this hierarchy. 1, your spouse. They are people who can approach the court for letters of administration intestate.
So hypothetically, just so that the viewer can understand it vizuri too. So hypothetically, a man, he's let's say 30 years old, has a wife and 2 children. So this man alikuwa na maguta, alikuwa na shamba mahali Thika Road, and other assets around Nairobi, for example. Sadly and unfortunately, he passes away over the weekend. So now what? So you say the spouse. So the wife to now this gentleman.
Yes.
Is the first So does it happen automatically?
No, that is the provision of the law. The law says the people who can approach the court to be granted the powers of administration. One, we have the spouse, we have children, we have parents, and then we have public trustee.
So it means this section, first of all, they have to approach the court first to be administrators. Hata wao wanaweza kwa jela if they do not go that route.
That is what the law is saying. Anyone, and actually if you can display that portion, it talks about anyone, that the first portion. So that no person means including even those who have the right by law, but they have not taken the right steps. It doesn't excuse anyone. No person. It means whether you are the person who is properly qualified or not, you cannot deal with the estate of a deceased person unless with the permission of the court.
Right. So hypothetically, again, for this, we'll use our gentleman who passed away. His name is probably Charles, and well, the wife, let's say, is Mary, for example.
Yes.
So Charles has passed away. So what kind of documents is Mary going to go with to the court?
Now, when somebody dies, the first document you ought to get is the death certificate. And then you'll get the letter from the chief.
Okay.
The chief is the basic administrative unit in terms of the succession, because they give a letter, one, confirming that you came, you hailed from that location, from their jurisdiction, and 2, you had property, and 3, who are the people who can be of benefit or beneficiaries to your estate. Now, when you have this documentation, you will approach the court. When you approach the court, there are 2 things you can get in essence. 1, you can get a limited letter of administration. Or 2, you can get a full grant.
Let's start with the first one, limited access.
When you're talking about limited letters of administration, these are authority or permissions given by the court to serve virtually all the purposes that you may want to serve, that which ought to have been done by the deceased. For instance, I'm going to give examples. Charles, that we have as an example, may have had children. These children, they were going to school. He was the one who was their breadwinner. He was the one who was paying school fees, and all his money was in the bank. He is dead. No one can be able to utilize that money unless with the permission of the court. So what the wife will do, will approach the court for a special grant.
Wait, so even ile pesa iko bank is also included in this property that we're talking about?
Yes. Okay. So the wife will approach the court with a special limited grant.
Right.
Specifying that I want to access 5 million from my husband's account so that I can feed the children and I pay for their basic need. The court will grant that. Okay. That is one type of a limited grant. 2, this husband may have been sued and there is a case in court. The wife in this case may be of benefit to the estate. So the wife will get letters of limited grant, letters of ad litem, so that she can be able to prosecute and proceed with the courts, the papers that are in court. 3, this wife may want to institute a case. For instance, maybe he died because of an accident as a result of a careless driver or a company, somebody who drove carelessly, and they want to institute an action against the driver or against the car company. With the limited letter of administration ad litem, she has now the capacity of the court to institute that proceedings. Another one, there is what the person who may qualify to be an administrator may approach the court. For instance, These Charles had some apartments.
Right.
They were tenants. He had farm inputs. He had very big tracts of land. They were produced there. This person will approach the court to be allowed to collect and preserve the proceeds of the estate. They are going to be given the grant for that purpose. There are virtually so many grants for the purpose of preserving and for the purpose of taking care of the immediate needs of the deceased. And the reason why we are calling them limited, because a limited grant does not allow you the power to divide or to distribute.
Okay.
It just allows you power to deal with the current circumstance. So contrary to the full grant.
Does it mean for the limited you always have to go to the court each and every single time? How does that work?
All the times you want to fulfill that specific purpose, you have to go to court. For instance, if you want to defend a suit or to institute a suit, you have to get the grant. And the limited grant, if it's for a suit, the court will tell you this person on this date is allowed to defend or to prosecute this case number at this location.
Okay.
So that it is limited to that specific purpose. If it is to collect, the court will state this person is allowed for the purpose of collecting and cannot distribute the proceeds coming from this property, this property, this property.
Right. Something that largely happens in Kenya, the immediate family doesn't even know that the man, for this case, Charles, hypothetical, doesn't even have all these huge tracts of land that we are talking about. Somewhere along Thika Road, Mahali, hawajui. So what if someone else, one of Charles's friends or his colleagues now come to the court to apply as an administrator? Does the court seek for the immediate family first? Waambie, relax kwanza, wacha tutafute familia, then now you can come and apply?
So if somebody not an immediate family comes, there are various circumstances where they can come. But essentially, if somebody died without a will, the preference is given to the immediate family. For this reason, one, the immediate family may be aware of the properties that this person owned.
Yeah.
And two, they may also be aware of the persons who are entitled to benefit. We call them beneficiary. A third party, a stranger, may not be able to know that information. The only time a person not in the family lineage is allowed to apply is if they are given leave by the court. This is what happens. If, for example, you are not in any way related to the deceased and you want to apply for letters of administration, you have also first to cite, we call them citation proceedings. You have to cite the persons who rank higher in terms of the hierarchy. What it means is that you're going to ask the court to allow you, above the people who are properly qualified in law, to apply for the letters of administration. You are citing them. The citation is not the succession per se, because in citing, you are asking the other party who is properly qualified, come to this court, explain why you've not taken out letters of administration. Come to this court and explain why those letters should not be given to me. Now, even in terms of the hierarchy, if any person wants to apply, they ought to be given the consent of the people who rank higher than them in terms of the hierarchy. So this person who is not a family member, they want to be given the letters, the court has to certify that, one, they have the permission of the other persons who rank higher than them, and two, they have demonstrated a reason. One of the most apparent reason why a third party may be allowed is if they are a creditor.
All right.
This is a person who the deceased had their debt. So if they have no reasons why I should not be granted, then let me be granted the powers to administer for the sole purpose of them being in position to recoup their debt that forms part of the estate.
Right. Let's talk about the timelines here. Hypothetical, Charles has passed away this weekend when July was just starting. So how long does Charles's wife have to file and apply to be an administrator? Because, I mean, you'd have examples of immediate family members taking years and years to even wanting to apply to be an administrator. And what effect does that also have when that delay
be taken as if we wanted this person to die. Some other people give reasons that we wanted at least time to grieve.
Okay.
So that then once that is done, then we can start the process. But of importance, and what people need to understand, based on the need, it's good for people to take action, because if they don't, they lead to wastage of the estate of the deceased.
Right.
How does the wastage happen?
Right.
One,
before you continue,
yes,
that on matters wastage, allow us to pick this call and hear what Vivian from Nyamira has to say. Vivian, habari asubuhi, asante sana for calling us this morning. Uko na swali au maoni? Vivian, hello, can you hear me?
Hello.
Yes, habari asubuhi.
Mzuri sana.
Asante sana kwa kutupigia.
Nimekuwa na swali.
Yes.
My husband died.
Yes.
And the brother-in-law has been on my case in terms of their rentals zenye bwanangu alikuwa amejenga.
Okay.
Lakini sasa after kukufa, the brother-in-law akakuwa interested nayo, akaanza kuchukua rent, you know, and that is what we were depending on, me and my husband, kulisha watoto na kila kitu na kuangalia watoto. Sasa now I'm in a dilemma that now she has taken over everything, na siwezi lipia watoto school fees, I can't provide, and my husband is dead.
All right. All right. We'll have Wakili answer you on that. Thank you very much, Vivian kutoka Nyamira. Salimia sana watu wa Nyamira. Remember, our phone lines are very open. 0795 045 864 is the number. All you need to do is tell us your name, where you're calling us from. Tafadhali mute or have your TV off, and then talk to us on the same. Wakili?
Yes, as we said, that intermeddling is dealing with the estate without the leave or the permission of the court. So if such a thing happens, one, intermeddling is a criminal offense. And how a criminal offense is prosecuted? You report to the police station, the police, they will do investigation, and then the prosecution will start. The penalty for intermeddling, the law has set it as 10,000 fine or imprisonment for 12 months or both. So, what should happen first? If there is intermeddling, and we try to define intermeddling, and it cannot be defined definitively, this is dealing with the property of a deceased without the leave of the court. As the complainant, you first need to report to the police station, so that the criminal investigation will start. Will start. Two, the people who are properly allowed by law to apply, they should apply. And you see, when you are applying, like she said that the husband died, right? Now she is the person who has a capacity to apply as an administrator. Once you apply, you can even seek an injunction. You can restrain that person from ever, one, collecting, dealing, directing, mandating the tenants.
Okay.
Because we'll have the letters. The papers will say the letters of administration for the estate of this person are given to Beatrice. Is Beatrice, right?
Vivian. It was
Vivian.
Yeah.
And then Vivian, if this guy continues to intermeddle, she will file an application in court saying, I am asking the court to stop this individual, his agents, his employees, or other people acting under his instruction from collecting, distributing, interfering, dealing with the property LR number belonging to the deceased.
Right. We have another caller, Rosalind kutoka Uyuges. Rosalind, habari asubuhi. Thank you for calling us this morning. Do you have a question or feedback on our conversation? Hello, Rosalind.
Hello.
Asante sana kwa kutupigia. Uko na swali au maoni?
Niko na swali.
Yes, uliza tafadhali.
Yes, I'm from Oyugis.
Yes, yes.
I'm Roslyn Ojuan.
Yes.
My father died in 1991.
Okay.
He had a plot in Kisumu in the CBD.
Okay.
He had 3 wives.
All right.
And 17 children by the time he died.
All right.
Then my brother sold this plot in 1993, the third born in our house.
Okay.
And he sold it alone without consulting any of us, even the mothers who are there, the widows.
All right.
Can we get help?
Can we get help? Thank you very much. Wakili will be answering that just right now. Thank you for that question, Rosalind. And
Yes.
I think also because I also wanted to ask this, can you backtrack some of these matters that happened way back in the years?
Yes, you can. Because the issue of succession is linked with the issue of the land, the property. Normally, the title issued to any person is by itself evidence that you are the owner, but that title can be impeached. The validity of that title can be challenged, and the legality of it can also be challenged. Now, if the title was passed because of using fraudulent means, deceit, forgery, that title can be annulled by the court.
Okay.
That's why you see, when you're talking about intermeddling, the other criminal associated offenses is forgery and perjury and misrepresentation, which are criminal offenses. For example, if that guy, I cannot be able to pass property or to give a good title to a property that belongs to you. That is the law. Unless I forge documents so that the title first comes to me and then I can pass it on.
So chances are...
this brother forged the documentation so that they came to his name so that he could then be able to transfer to somebody else.
Right.
If that is the case, the title to that land can be challenged.
It's 30 years plus, and Rosalind is still asking because she says this land was sold in 93.
Yes.
And the father had a plot, I think in CBD,
yes,
as she says. Again, something interesting, a whole other dynamics, because you told us that the spouse would get immediate, the court would really look at the spouse really.
Yes.
But then here there are 3 wives. So
there is the provision of the law on how...
the court,
now, when you're talking about the administrator, the law allows a maximum of 4 administrators.
Okay.
The minimum of 1. So, if there are 3 wives, by themselves they can agree, we will all be administrators. If not, then we give a representative from either of the family.
Okay.
The reason why I'm saying it is possible because there is no timeline when you can prosecute a criminal case. The moment you understand there is this fraud that happened, this is what might have happened, then you are obligated as a person to make a complaint. As well, the law does not help indolent. What that means, if you know you are a cause and there is nothing you are doing about it, you may find that your course of action will be abated, or how you can be able to defend it, there may be so many inhibition as to how you can defend it. What at the moment you understand there might have been fraud that was committed, the first point of call is to report. Because fraud is a criminal offense, it can be prosecuted at any particular time.
So Wakili, in this case, does it mean, because again, it's 30 years plus.
Yes.
Hypothetically, if, because she says this plot was sold in 1993.
Yes.
So far, I think it's about 30 years plus, somewhere about there. So hypothetically, if mtu alijenga nyumba kwa hiyo plot, right now, if Rosalind and the family go to court and they win, does that mean an eviction in that plot?
Exactly, because you received the wrong title, or the title you received was not a clean title. What will happen? This guy will be evicted, or they can give him option. Or you can buy us out, and then follow the money you paid from the guy you paid to. Because for us, this is our property.
Okay.
They can agree. That's the beauty also of the law of succession, because the court allows the parties to have discussion on how the dispute can be solved.
Okay.
So that if it is found that the land you are standing in was not properly sold to you, therefore the rightful owner has a right to evict you. And you have also an obligation, if for example, you have built your house, and they want to evict you, you can negotiate with them. Let me buy your rights out.
Right.
I pay you.
Right.
So that then it will be, they will also have an opportunity to follow from the person they paid, because the person who sold them a property in which he did not have the right to sell. So then it is purporting to be in position to do something, yet you cannot.
Interesting. Allow me to take a look at other comments and questions. First of all, on our WhatsApp. Remember, our WhatsApp number is just below your screens there, 0793267279. I'll be reading them for Wakili to be answering them. I'll start with hello, good morning. I'm Immaculate Njeru from Kirinyaga County, but living in Machakos. My father died in 2016. He was working in Embu town, a company called KARI, that is Kenya Agricultural Research Institute. My brother and me, we have followed his month. We have get some money, but we are waiting for retired money. Can the advocate in the studio help me and my mom? I
think she is talking about the benefits from the company.
Okay.
What happens, and this is important for me to mention, the property that goes through the succession is the property what the Act defines as the free property. Free property is the property that was singularly and individually owned by the deceased. Not the property that the deceased held together with other people.
Okay.
Or not the property that other people's had stake in. There are other schemes where the deceased may have invested. In those schemes, most often you see that they are told to give a nominee, or the person who may benefit in the event of their demise. For instance, a life policy or other types of policies that people take. You find that they are told to give a person who will benefit from such a scheme. Upon the death of that person, then the beneficiaries properly mentioned will approach the organization. They will be guided on how they can get the benefits.
Okay.
Before
we continue, before we lose this caller from Muranga, is it Linus or hello, TV47? Lina, karibu sana. You have a question or feedback? Hello, Lina. Oh, my apologies. I'm being told it's Maina from Muranga. Uko na swali, Maina, and karibu sana on this conversation. Do we have Maina on the line? Hello Maina, kama unanipata uko na swali au okay, ni kama Maina ameenda. You're talking about matters, policies, and now even on the whole bit of SACCOs, because again, this is where most people really buy properties.
Yes.
Mostly. And at times the family might not really know, but then now for this case, does even the SACCO itself have the right to be administrators?
No, the SACCO doesn't have the rights to be an administrator because the share of the deceased can be identifiable or is identifiable in the SACCO. So what there is, I believe in some of the SACCOs, one is supposed to or required to have to provide the names of their nominee or the beneficiary, that in the event of anything, that is the person who can benefit. So the obligation the SACCO has is to get in touch with the persons who are from the estate so that they can advise on how will the proceeds or how is the portion of the deceased to be given.
Right.
But even then, nothing stops from the family once they approach court to decide, if there was no person named, to decide that for the SACCOs in this scheme, this is the person we want to benefit. Okay. So that then, once the papers are out, that guy will approach the society, and the society will effect the benefits in his favor or in her favor.
All right. And still looking at more questions on WhatsApp. Kelly, my name is Kelly. If a wife is dead and the husband decides to marry, can the man sell property he built to the first wife without the consent of the children?
Interesting. Now, there is another concept that is closely linked with the issue of succession and the issue of the matrimonial property. The matrimonial property is for the benefit of the spouses. And this is divided mostly upon the dissolution of their union. If it is death, and this property was a matrimonial property where other individuals had an interest in, yes, the children can object to the father selling the house that their mother had a stake in. So what needs to happen then? Now, in terms of the joint property,
okay,
there are two forms of joint ownership that we have.
Okay.
There is the joint ownership, in the strict sense, and the ownership in common.
Could I ask that for those two, hold on, as you pick Festus from Athi River, and when you get back, you can elaborate more on that.
Okay.
Festus, good morning from Athi River. Watu wa Athi River mnaendeleaje? Hello, Festus. Festus, kama unasikia, habari asubuhi? Right, kama Festus pia amepotea. 0795045864 is the number to call us. Keep calling us and we'll be sampling your questions. Wakili will be answering them. So back to what you're
yes.
telling us.
Now, if this property was held in common between the spouses, then the share of the wife or the husband is identifiable upon death of one of the party. You find that in most cases, and some of the cases I've done, you find that the husband and the wife owned property together. So that what that means in joint ownership, what that means that upon the death of one of the party, the property will pass to the other without even having to go through the process of succession. If it was joint in common, it means that the share of the deceased can still be isolated from the whole, so that then the children can claim the share of that portion that belongs to their mother. But in the normal sense of things, if the property was joint in common and one of the party dies, what the other party need to do is to take the death certificate and other forms, so that then the name of the deceased will be removed and his name will be put there.
Right.
The implication is that this property then absolutely becomes the property of the person who is surviving. That is the law. Right.
Still more questions. There's someone who is referring to the Rosalind from Oyugi's case, saying consider that case. What's the brother didn't forge anything since his son of the deceased, he went to the chief, got the letter and then proceeded to court and acquired grant for administration and then acted on it. Is that not legally binding? Number two, after how long can the sale be revoked? Like this for this case is almost 30 years. Keep that in mind as we also pick Moniki from Embu. Mwaniki, habari ya asubuhi, asante sana for calling us this morning. I'm Stanley Ringita. Uko na swali au maoni?
Niko na swali.
Yes, uliza.
Yes, mimi babangu alikufa in 2013.
Okay.
Na alikuwa mwalimu kwa muda mrefu.
Okay.
Na tukaenda kwa succession, imemalizika, manake tulianza 2018.
Alright.
Mamangu ambaye alikuwa pia ndimi naye akakufa, tukaanza kesi tena.
Okay.
Alafu baada ya hiyo tukamaliza succession yote, tukachagua wadini wawili kwetu nyumbani, we were 12 kings. Sasa imeenda hiyo succession file imemalizika, imeenda Nairobi kule kwa pension. Lakini kuangalia nikaona 2022 ndio pesa ilikuja kwa public trustee.
Okay.
Sasa hiyo file ambayo tukamaliza succession tukapeleka kule kwa trustee, wakapeleka Nairobi.
Right.
Na ikarudi tena.
Okay.
Ikiwa imefanywa calculation yote pamoja na interest. Sasa the problem that we have, tukienda pale kwa ofisi tunaambiwa kwa tutatengeneza siku nyingine tukaambiwa hata file haiko. Alafu tena ndugu yangu akaenda akaambiwa wewe tutatengeneza, tulikuwa tunataka kufunga mwaka wa serikali.
Okay.
Yaani sasa imekaa sana.
Okay.
And you have done a lot and you have done everything that is required.
Right.
Sasa we need to know whether there's a legal redress or what can we be able to do so that we've been given our benefits.
Okay.
Manake imekaa sana na ni hapa Embu na file iko pale haifanyiwi kazi. Iko pale tu, it was supposed to check iandikwe. Na tupewe tukaweze kuweka kwa account.
Right.
Yes, that's my question.
Asante sana Mwaniki. Wakili will be answering your question right about now. Thank you. Salimia sana to Embu. How can we help Mwaniki?
Yes, at least Mwaniki they have done that which is allowed in law. Now their action is not even in the succession because the succession is done. Is now compelling the public trustee to process their payment. If, for example, there is no justification or reason why the public trustee has not acted on their prayer, then they can go to court to have him compelled.
And just to build up on that, even as you continue, I'll also ask our director to say in section 46, because it mentions what you're talking about.
Yes.
The duties of some of these officers as you continue. Well, there you have it. So, yeah. Apart from now the public trustee,
yes.
What exactly are the roles here?
Now, the public trustees, they are also among the people listed in section 66 as people who can also take part in ensuring that the estate of the deceased is properly administered. Now, in this case, this particular case of Mwaniki, now that the proceeds are in the scheme of the government, the public trustee is obligated to ensure that the proceeds or that which ought to devolve to the estate goes to the estate without wastage. So that then, if there is unreasonable delay in execution of the mandate, then they can be questioned or called to account as to why are they not helping? Why are they subverting justice for this? Because the law says, justice delayed is justice denied. Then this person in their official capacity, they are using their position to delay justice, in which this family has a recourse. So therefore the court can compel them.
Okay.
The same as, you see, the section 46 mention also the police. The police, they can investigate, they can take action on any person who is intermeddling, because it's a criminal offense. Intermeddling or dealing in a manner that does not or is not allowed by law to deal with the property of a deceased person.
Right. Okay, let's fill a couple of questions because they're coming in. People are really throwing in very many questions on WhatsApp. The one that
Before
I had
I forget,
asked,
there is a question that was asked for after how long?
Yeah.
Now,
Oh yes, it's actually the one that I was about to refer to. So someone was asking, good morning, consider the case of Rosalind from Oyugis. In case you're just joining us, we had a caller from Rosalind from Oyugis. What's the brother, if the brother didn't forge anything, since he's a son of the deceased, he went to the chief, got the letter and then proceeded to court and acquired grant for administration and then acted on it. Is that not legally binding, number one? Number two, after how long can the sale be revoked? Like this, for this case is almost 30 years.
Now, that's a very good question, because Section 71 and Section 76 of the Law of Succession Act, they provide grounds upon which a grant can be revoked. Now, the process of filing, which we will shortly, we can mention briefly, at the final point of the concluding the succession proceedings is where the parties who are all beneficiary agree that property A goes to Njoroge, property B goes to Wanjiku, property C goes to Kamau, property W goes to Otieno. And you see, if this party consented, because there should be a consent on the mode of distribution. The property does not belong to the administrator. The administrator cannot deal with the property without the consent of the proper beneficiaries. Now that the wife is saying, I am not aware, it means that they were not involved in the process of the confirming the grant. And therefore, they were not aware as to who was to benefit. So it means that, let's even assume the husband or this guy got the letters of administration. Then they breached their fiduciary duty of administering the property according to the wishes of the beneficiaries.
We do have Maina from Muranga. I believe maybe he's the same Maina who had called earlier. Maina, good morning. Thank you for calling us. Uko na swali au maoni on our conversation today? Maina, can you hear me?
Hello.
Hello, yes, I can hear you.
Hello.
Yes. Uliza swali?
Hello, I'm morning to you.
Yes.
Niko na swali.
Yes, continue.
Swali langu. Hello.
Yes, endelea na tafadhali paza sauti yako kidogo.
Nauliza swali kwa kuna kesi tulikuwa nayo is most na ile kitu mnaongea. Tulikuwa kotini jana Muranga.
Okay.
Hello.
Yes, Maina, we can hear you. Proceed.
We can hear you. Continue.
Sasa kuna mtu ambaye ni Mayanko, watoto wa Mayanko. Sasa bibi yake alipoaga.
Yes.
Nasema.
Yes. Maina, tafadhali
watu kuna mama ambaye alikuwa ni my cousin. Sasa bwanake akaaga.
Okay.
Bibi wakashikana watu wengine wakauza shamba.
Okay.
Immediately wakauza shamba yote na wakawa hata hawa watoto hana shamba.
Okay. Na
waka influence watoto watatu, wakaacha wengine hakujua shamba ilikuwa inauzwa.
Okay.
Sasa watoto wakafurushwa kwa hiyo shamba.
Right.
Na sasa wamekuwa sasa hakuna pale wanakaa.
Okay.
Sasa mwenye kuuziwa ameenda kotini. Anataka hawa watu wa transfer shamba na hiyo mama. Sasa kesi imesikizwa sana kotini na judge kwa hilo welefu wake akasema watu waende kwa mediation. Ilikuwa kwa mediation jana.
Okay.
Na nikauliza huyu mwenye kununua shamba, alinunua shamba na hawa watoto waliacha wakiwa na nini? Sasa wana demand transfer hiyo shamba. Na mimi nikawaambia hasa hawa watoto hana pahali pa kukaa na shamba imeuzwa wote na huyu mama.
Okay.
Na sasa hiyo mama alikuwa hajapatiwa letter of administration. Hata sasa alikuwa hajafile.
Right.
Hii watoto ambao hakuhusika na mambo ya hiyo shamba ni kwa saidia kufanya succession.
Okay.
Na mama amepatiwa letter of administration.
Right.
Sasa wanataka kutumia sasa ndio administrator ndio watransfer hiyo shamba. Sasa nilikuwa nataka wakili ni advise because we have given another date for mediation. Ndio tujue vile mambo itaenda. Na hasa mediator nikaona hasa mama kama anaegemea upande mwingine anasema ile hao mama alichukua hiyo pesa nusu. Ile warudishio pesa na faida Okay. Walikuwa wamepatiwa milioni 1, okay. Shamba walikuwa wameuza milioni 2. Which is walikuwa wamefanya afali ilikuwa chini kabisa. Kwa hata huyu mama mwenyewe hata hajui vile shamba inatoka, hata hajui mambo ya shamba. Wakili mwenyewe aliandika agreement, alikuwa amesema wakibreach hiyo agreement warudishe 100%.
Okay.
Kucho hata nashindwa 100% sijaona agreement. Na tena anafanya kuandika agreement akijua hiyo shamba tena ni ya marehemu na anajua.
Okay.
Chifu mwenyewe akaingilia ndio hasa hiyo shamba sasa watoto wafukuzwe.
Right. Na
chifu mwenyewe ndio alikuwa sasa mwanzo a protect hawa watoto. Sasa nauliza wakili, because we are going for a mediation. Our stand ni gani? Nilikuwa nasema hivi tutatafuta pesa hatu tuwarudishie the amount walikuwa wameelewana. But now they wana demand pesa mingi na still they are in the last land for 11 years. Wanalima watoto hasa wako wamekuwa chokora. Hakuna bahali wanasaidika. Sisi wanafanya ndio tegemeo ndio sasa watoto ni mimi watu wengine.
So asante sana Maina
for that. Okay. Tutatafuta hiyo milioni tuwarudishie without what is your interest, because hiyo shamba ametumia for 11 years. Na wana demand hata wanasema mtu asiingie kwa hiyo shamba. Waliambia watoto wabaya hakuhusika mambo ya kuuza shamba, wakiingia huko watawakatakata.
Okay.
Na mmesikia wakili amesema tuwezaenda police to report that case because nimesikia amesema is a criminal offense.
Yes.
Sasa nilikuwa nataka advice ya wakili.
So asante sana Maina from Murang'a for that very lengthy.
Na ni vizuri nimefurahia kuleta hiyo kipindi.
Sawa anajibu tu sahihi hiyo swali. Asante sana Maina kutoka Murang'a. Wakili, yes. That's quite a lengthy question. I can see the time is not on our side. More questions are still coming on board. You can probably unpack his question because there's so many who are asking on his behalf. He's asking on their behalf rather. Just a brief, and then later on you'll also be sharing your contact so that now they direct all these questions to you.
Yes, and I wish to address Maina in Swahili. He seems comfortable on
yes.
It. Sasa kile kitu ambacho kimefanyika, Maina ameelezea kwamba hili swala liko mahakamani, na kama vile tulisema pale mwanzo, ili kushiriki ama kuhusika na mali ya marehemu lazima pawepo na idhini ya mahakama. Kwa sababu ni ukweli pale hapakuwa na idhini ya mahakama. Kwa hivyo wale watoto ambao mama yao aliuza shamba pasipo kuwahusisha wako na haki kufuata mali ya marehemu baba yao. Kila kitu ambacho kinafaa kifanyike, na kama mahakama imewaeleza, endeni mzungumze, kwa sababu suluhu ni hili. Huyu jamaa mnunuzi alilipa pesa, na mama ya wale vijana alipata pesa na akaruhusu shamba lipatiwane pasipo na idhini ya mahakama. Hilo jambo ni kupita sheria. Kwa hivyo kisheria hili shamba halijamwendea mnunuzi kwa njia zinazofaa. Hivyo basi anafaa awasikiliza wale vijana, kwa sababu wakienda mahakamani wako na haki zaidi yake. Japo alilipa pesa, chake ni pesa. Shamba, umiliki wa shamba bado uko katika jina la marehemu. Kile kitu ambacho, na amesema vizuri, kama patakuwa na makubaliano, atawaeleza ya kwamba mimi sina shida kuwarudishia shamba lenu. Kile kitu ambacho ningetaka mfanye, mkimuhusisha mama yenu ambaye mimi nilimpa hela, ni arudishe pesa zangu ambazo nilimpa. Kile kitu sasa wanafaa waelewane. Kama kutakuwa na nyongeza, itakuwa nyongeza ya hela ngapi?
Okay.
Kuna uwezekano wapate suluhu pasipo kujipiga kifua, kwa sababu sheria ilivunjwa katika umiliki wa shamba ya mtu ambaye amefariki. Okay. Na watoto wako na haki kisheria. Amesema jambo lingine ambalo ni la muhimu katika kusuluhisha ama kufuatilia mali ya marehemu, wahusishe watu wote.
Okay.
Iwapo kuna mtu atakuja kusema mimi si kuhusishwa, mahakama itamsikiliza, kwa sababu sababu ya mtu kuhusishwa ama kutohusishwa ni kumaanisha yule ambaye anataka kutomhusisha mwenzake, kuna mambo ambayo ya kisiri ambaye amefichama anataka kumfanyia huyu mtu ambaye hamhusishi. Kwa hivyo cha muhimu kila mtu ahusishwe. Pasipo kuhusishwa, kimbia pale mahakamani. Yale mambo ambayo yamefanyika pasipo kuhusishwa, omba mahakama yafutilie mbali.
Sawa. Asante sana. Some nice Swahili, by the way.
Thank you.
Your parting shot, as well as actually, just give us your contact, because there's so many questions here. I may not even get the time to read through them, but then give us and share to us your contact where someone can reach you.
Yes, one, you can be able to get us in on our website, Macharia Gaitho and Murigo Advocates. You can get our contacts there. Additionally, my phone number, which you can text me or get a booking, is 0704-259-382. 0704-259-382. Our offices are located in Bruce House. Bruce House is in Standard Street, along Standard Street, just besides the 680 Hotel or the county government offices of Nairobi.
All right.
Either 8th floor, suite 804. And I believe our viewers can get justice.
Most definitely. Thank you very much, Wakili, an advocate of the High Court, Paul Macharia. There's someone who was saying he's missed a better part of the conversation and asking where can he get the whole episode. On our YouTube page at TV47 KE. Check out there, just watch the whole, and utapata pia namba ya Wakili there. You can also share to someone who really needs this conversation. That has been Matters Law right here on Thursday, because we do this every single Thursday, just helping you on matters legal. From matters maswala ya sheria